I'm Edgar Hall. I'm going to be speaking to you today about debt issues. And the good thing is this can be very fluid. I can follow these slides exactly, but most of you are going to have this material already. What I'd like to do is get a sense of what type of debt issues you're dealing with when you're dealing with either veterans, military members, etc. Who's dealing with collection claims from creditors? Got that a lot? Anybody else dealing with a lot of collection claims? How about foreclosure issues? Any foreclosures? Okay. And how about bankruptcy? Okay, so we got a couple people dealing with these a lot. The rest of everybody, this will probably be informational. So what I want to do is broadcast this to as many people as possible and go over this very generally then. Let's say everybody in here was getting collection claims. We could spend 25 minutes on that and really hit it hard. So the main thing that I would like to start off this conversation with, and I do some of the APR 8 CLEs and other things for military members coming in, is I like to focus on the military-specific issues that will not affect civilians when you're dealing with debt issues. First off, if you are active, you're looking at Article 134. Now, to the JAGs in the room, I don't need to explain this. To the ones that aren't, the bottom line is part of 134 is you can suffer consequences for not paying your debts. I was enlisted for a long time. It never happened to me, but as a lawyer, I see this sort of thing. Security clearance issues, you can go to the guidelines, but a lot of people are afraid to file bankruptcies because they might yank your clearance. They're afraid of going in debt or a creditor threatening to call their first sergeant or their commander, whoever. Even though there are FCRA violations and FDCPA violations and all sorts of violations, they still feel that. And the DoD guidelines do allow for the yanking of security clearances for failure to pay your debts. We're going to go a little bit into the standards on that. The SCRA, Service Members Civil Relief Act, that's going to apply to members and guardsmen and reservists. Well, it's the updated version. So they called it service members to be, well, for whatever reason they chose, that's the new name of it. But yeah, it's basically a continuation with a few changes. I won't go deep on the changes. That would be very specific and narrow for what we're doing today. But yeah, it's the newer version of the act. Then, of course, we have deployment issues, like Ms. Simpson was talking about. You're not necessarily going to have your case held up forever just because you're a veteran or a member, but there are some timelines you can get. And then, of course, creditors contacting your chain of command. For former members, veterans, the big issue is really, can your pension be garnished? And the good answer is if it's a non-governmental agency, pretty much no. With very few exceptions if you get into commingling funds, etc. Again, this is the general list. We'll go into all this specifically later. All right, 134. I did not want to get into this in depth because I never know the number of military members in my audience, and I really don't need to preach to the choir. But if you go into it, you're going to see, specifically for debt, there's going to be 4 major factors, and there's going to be explanatory guidelines if you dig a little deeper that parse these out. And the real issue is if you look at the bottom for the key concepts, what they're trying to do is they don't want you acting dishonorably. They do not want you prejudicing good order. They don't want discredit upon the armed forces. That's really what the sum of this theory is. So let me give you some examples of what I've heard of members, because I don't do defense. I don't go to courts martial. I don't do anything. I'm a civilian. You go and you rack up a bunch of debt at the casino. You advance credit cards and you want to go file a bankruptcy on it. That's not a good reason. That's probably going to result in punishment if someone decides to check you out and go after you. On the other hand, let's say you fell in love with a person. They brought a lot of debts into marriage. You are completely overwhelmed on your enlisted salary. It's not going to be the same thing. As long as you clean up, you take steps to do so, file bankruptcy, do debt consolidation, settle. That's what they're looking for. And then, of course, issues of how long do you let it sit? Do you sit there for 5 years ignoring it, and all of a sudden, here they come looking for your security clearance? Or on the other hand, do you realize, I have a problem, let me go get financial consulting, maybe psychological if that's at play, and then what do I do to fix it? But again, if you're dealing with veterans, this is not really going to be a major issue. This is only for members. Security clearance issues, this can affect some civilians. A lot of the standards are almost identical, if not identical. So if you got a Boeing employee or someone like that that's carrying a pretty high clearance, these type of factors will play. So again, what you want to do is you want to look at the DoD or the CFR to get this, and I put a little bit here. This is the main issue. And if you just take the first line, that pretty much, I mean, it's a very long run-on sentences, most codes are, but are you living within your means? Are you showing lack of judgment? Are you trying to game the system? If you are trying to game the system, chances are this is going to violate the security clearance guidelines, and you very well likely lose it. I had one client lose clearance because they started off with a Chapter 13, chose not to continue in the Chapter 13, said, to hell with it. And it got yanked, and last I heard, he's probably going to be discharged out. Again, you can go to the very specifics, which gets very in-depth, which I don't want to bore everyone with. This is all online. So if you have a client that has a concern with security clearance issues, they're coming to you for some sort of debt consultation, you can either send them over to someone that has experience with this, you can tell them to look at the source, you can look at the source, or whatever the case may be. There are ways to appeal these. I've gone to some of these hearings to explain as their bankruptcy attorney or as their debt attorney, these are the reasons why we chose this is the counseling we did in advance. And I try to testify to the person's character to the best of my ability with my limited knowledge as their advocate. And of course, disclose I am biased. But I show every step and the numbers to the administrative law judge if this is what we are doing to fix this. This is his good faith or her good faith effort to fix this. And in general, you know, if you're a good person, you have the right things in place, they're not looking to just throw you out of the military. They're really looking to work with you. And that's what these guidelines are about. Mitigating conditions, this is the big one. This is really, like I said before, you're trying to show that you're a good person. Did it happen so long ago, like under A? That's unlikely. So maybe when you were 20, you did something stupid, you got in over your head, now you're 25 or 30, and you only happened that one time happen. Were they beyond your control? So again, did you marry into the debt or did you cause it? Was it an accident that you got into and maybe you were at fault? You weren't drunk, but you were still at fault. Or did someone run into you and your bills racked up? Again, you can go through these. These are all online. SCRA. SCRA applies both to civil, but also to bankruptcy proceedings. A lot of people aren't aware of that. One thing that I can say is if you have a military member that's going to be deployed, again, that's going to be one of the key inquiries. If they need some time, the courts are going to work with them. I've had people in Afghanistan file bankruptcies here in Washington. I've had people on ship in the Navy file remotely, and you just set up the camera, you just set up the video link. You can even do it by phone if the judge is inclined. Luckily in this state, the judges are very pro-military. I've never seen a judge just say, no way, I'm going to make that guy appear or else, or that female appear or else. They work with you. And so it's been pretty much a joy for my practice in dealing with military members that have to file a bankruptcy. Again, for veterans, this has extremely limited, if any, application. I have one of the few practices that I can say I truly enjoy as a lawyer. I have a fun practice. I get to attack debt collectors, tell them where to go, sue them for it. I get to discharge big debts and have people have fresh starts. Okay, deployment issues. Venue is going to be the big issue, especially if you're looking at a bankruptcy scenario. The way bankruptcy works, it's going to be the greater stay in the last 180 days of where you've been. So let's say you just mustered in from Georgia. Here you are in Washington. You've been here 3 days. You want to file. Well, technically, they might want to have you use Georgia rules because you haven't been here long enough. So solutions, wait a little bit if you don't like Georgia rules. Or, well, wait a little bit. Meeting creditors, again, you can seek permission to go by phone or Skype. The judges and trustees are very open to this in my experience. A little trick, if you do somehow run across a judge, and I've heard of this happening, or across some sort of creditor, someone where they're not working with you, you're deployed, you can't really defend yourself, and we're not talking a divorce proceeding where the house is divided, but we're talking about a nice married couple here. The spouse can file individually. A lot of people don't know that. You can actually do an individual bankruptcy under a theory of community property. The whole community gets the discharge as well, so it's a backdoor discharge for the non-filing spouse. Explaining this to a separate property state creditor is near impossible, so pretty much you have to tell them, just sue me, and we'll take it to court, and you can tell that to the bankruptcy judge here in the Ninth Circuit. But it technically works. It doesn't work on everything, so let's say the non-filing spouse has a separate debt. Well, that's not covered because it's not community. So that's where so if you got a 20-year married couple, it's pretty much going to cover most things. You have a 1-year married couple, they're probably going to have separate debts, and so that may not be the way to go, but you can also do separate bankruptcies if you have to. All right, if creditors are contacting your chain of command, again, for the veterans, this doesn't really apply, not unless you're looking at slander somehow. For military members, it's an absolute violation of the FTCPA. This is a nice, big, high-money suit because judges don't like creditors already. They certainly don't like creditors messing with their military members. And it's a slam dunk case if you ever find one of these. It's just fantastic. So if you're screening anyone in any of the clinics and they say, yeah, they threatened to call my first shirt said, you're paying it no matter what. Well, you can pay it, and then you go back and sue later. Consider that cover damages. But in general, the person also has to have the reality of, this is my military career. I have had people come in to me for initial offense and then say, no, my first sergeant said he's going to kick my butt. I'm just going to pay it. I never hear from him again. I've seen that. I know it happens. So again, it just depends. All right. This is a big one that I like to start off with, because if you're dealing with someone in a clinic, understanding the character of the debt is really the key to everything. Because once you know what's dischargeable in bankruptcy, you understand how the creditor thinks. What the creditor's sitting back, he's done analysis on like 5, 6, 7 factors. When I run the credit report, do I see money? When I run the extended family, do I see money? Do I see someone about to die and therefore see money? Are the debts dischargeable so they can hide from me in bankruptcy? So will they hide my money from me? It's all about the money. That's why you're a creditor. So it comes down to secured, unsecured, priority, and unsecured debt. Secured debt is very straightforward. It's your house, it's your car, it's anything where you have a piece of collateral with an obligation tied to it. So if you don't pay on it, they take that collateral back from you. Very straightforward. Unsecured is going to be something where it's not tied to collateral. This is the widest range of debts. It could be your tax debt. It's not tied to it. They're going to put a lien on your house, but that's a later, that's another action. It could be credit card. That's not secured. It could be almost anything, loan to family, friends. The priority swing is there certain types of unsecured debt that is generally non-dischargeable. So it's going to be your child support, family law related debts, criminal restitution, tax debts under 3 years, or other certain tax debts. There's about in the bankruptcy code, I think it goes from A to J or something, or maybe even M. It goes pretty long with all the categories of non-dischargeable debts. If you got a DUI and cause personal injury, though if you get a DUI and don't cause personal injury, you're fine. If it's property damage, you can discharge that. But you hurt a person, not dischargeable. So there's a long list of those. So that's the first. So I think what I'm going to do is stop and take this on for about 5 minutes, because it's one of my biggest topics. I'm one of the few attorneys in the state that will do bankruptcy hardship discharges. And also I sue and litigate in state court. I've won trials on where a creditor went past the statute of limitations. Goodbye $40,000 debt. I mean, it really comes down to this. Federal loans have no statute of limitation. You want to wait 30 years to pay it, you got 30 years of interest. Private loans, they have a statute of limitations. It's based on the state you're in. If you wanted to get into conflict of laws, you can see if the original loan, click wrap, or whatever you signed has a choice of law clause. If it's Delaware, I think that's about 3 years. But Washington has a weird thing where they do the longer of here or there. So you go through that analysis, but that's the first thing you do is separate federal from private. If it's federal, you also have IBR, pay, repay, probably about 10 or 20 different programs unless it's a Parent Plus. If you're a parent and you sign for your kid, you're in trouble, unfortunately. There's not as many programs to help you out. And that's the first thing, is separate out the federal from there. There's a site, I don't have it memorized right now, but if you look online, you should find it first page. There's a national database where it lists all your federal loans. So that's going to be the first step, is you go to that database, pull up all your loans, and say, okay, here's my federal chunk. Next step you do is you pull up your credit report, because I guarantee you it's on there somewhere. And now you're going to get your private loans. You mash those together, and then you think, well, when was this reported? How much interest is bearing on it? Am I in default and paying default rate, because they're going to want the 12% pre-interest judgment rate, or am I paying contract rate? What am I looking at? And you start to have an idea of this is the total mess. Once you have an idea of the type of debt, then what you're going to do is say, well, what federal programs do I qualify for? Because before you go for a hardship discharge in bankruptcy, you have to say, am I in one of these programs that's going to let me pay 10% or some other smaller fracture, $50 a month or whatever? Because a bankruptcy judge can say, well, why aren't you in that program? I've seen them tell people that. You brought this big suit, you paid this lawyer all this money, why aren't you in this program on all these federal loans? You're going to be paying $50 a month. And they're going to dismiss your adversary proceeding. So I always have all my clients do that. Now, is that a right analysis under the bankruptcy code? There's argument. But it doesn't matter what the right analysis is. If the judge stops you, you got to appeal it and pay more money than the loan's worth. You just got to pick your poison. Once you move past the federal loans, which you can look at settlement, and there's a guideline. You just go online, put standard settlement guideline for student loans. It's brutal. It's like, oh, we'll take off a little bit of interest. I mean, there's next to no negotiation. Or you have to go for an individual consideration. And that really varies a lot. And since the government, they can take your pension, they can take anything they want, they're really not inclined to settle with you. And what's worse is the government allows cost averaging. So they can send you one letter that says pay up or not, and that's now worth about 30% of the debt. And they say, well, cost averaging, some will go to trial, some won't, so sending that piece of paper is worth 30% of the total debt. It's absolutely ridiculous, but again, they write the rules. I have problems with them, so all I can do is try to help my legislatures fight them. So go Warren, at least for student loans. So that's that portion. Now to resolve federal loans, you're looking at settlement, you're looking at payment programs, you're looking at special repayment programs, you're looking at, are you a teacher, are you public interest, can you get a public interest discharge, are you permanently totally disabled, do you have a medical condition? And there's a whole host of factors, all online. Go to Department of Ed's website, they're very good with telling you this information. You always have the fallback of a Chapter 13 plan. So if you want to just say, all I have is $100 extra a month, I'll pay that. That'll keep you current. Your interest will accrue, but they can't garnish you, they can't add attorney fees, and that's really the big kicker, is keeping the attorney fees off. Once you get to private, now you're talking, it's a combination of, there are no programs to help you. Bankruptcy is rarely an option. I know the bankruptcy judges, I saw them, some woman came in, and she was single, she made maybe $40,000 a year, she had 3 kids, husband left her, and the judge was screaming at her, this is a sitting judge, I won't say who, saying, why do you need a minivan? That's too big. And she said, well, sometimes I take my kids to events and they have friends. Like, this is bankruptcy court, your kids don't get friends. That's the impression, that's the standard they have in the Ninth Circuit. So that's why you hear in the news hardship discharges are very difficult to get. Now, the secret tip is the creditor attorneys, they never know how it's going to play. They don't know if they're going to get a soft judge or a hardcore judge. And so they're likely to just rip off 50% and say, how about we just take off half the loan, re-amortize it in 15 years at 3%. So just for having filed the adversary proceeding, you're likely to get a big discount. This happens all the time for my type of clients. And there's other defenses, fraud. I had a guy whose daughter signed his name, forged it, sent it to a handwriting expert and said, ta-da. They didn't even fight me. They said, okay, discharge, that's fine. We'll just go after the daughter. Or say, here's your address, go for her. So you have your full range of defenses, statute of limitations, fraud, mistake, accounting errors. They love to jack up accounting errors. I've seen 100% APR calculations, assuming you're not smart enough to go through and actually do the P equals IRT or I equals PRT and do the hand formula and actually figure it out. So when you're doing that, it's just like any other debt. You're just defending it, so you're going to do your discovery, you're going to do all that sort of thing. And you're just looking at cost-benefit analysis. So going back to the question on, it would fit into here generally. It's not technically priority debt, but because it's non-dischargeable, it treats it like this. But this is the problem. When it gets in the unsecured pool, so let's say I owe $100,000. So 50 of it's to a credit card, and 50 it's to the student loan. Well, under bankruptcy rules, it's going to divide equally if I'm doing a Chapter 13 payment plan. So all the unsecured debt gets in an even pool. So even though this is surviving, I can't tell the court, well, just take that because it's going away anyway and put it on the student loans. It doesn't work like that. So one of the advanced tips is settle everything you can that's non-dischargeable. Pay 50 cents on the dollar. Pay whatever you can on the dollar. I've actually recommended everything from hard money loans to go through and clean this out, wait a couple years and actually file at some point. Or do some other hedge to where, or family members, anything you do, loans against the house, especially while you're solvent or especially while the market's going up. If somehow that technique fails, well, now you've basically had a chance to maybe go out there and revisit that debt. So anyway, that was a long explanation for what sounded like a short question. I hope that helped. So anyway, yeah, that's the categories. So the way a creditor looks at this is good money, because they're going to take that collateral back. Depending on whether they're getting a deficient judgment or not, it's going to be there. And they love it. And of course, they can just foreclose or repo it or whatever the case may be. Unsecured debts, they understand. If you file a Chapter 7 bankruptcy, you're walking on that debt. If you file a Chapter 13, they're in the unsecured pool. So if you happen to have an expensive house that's getting paid first, they might get 0%. They might get 1%. They might get some horrible percent. This is pretty much hell. Because they know you're not getting rid of them. They don't care how small of a portion they're going to get. And they know their interest is going to accrue along with their attorney fees over the course of that Chapter 13 plan, and a Chapter 7 doesn't get rid of it. So that's the worst of all worlds. The family law debt is brutal. It's right there. So when someone comes to me with back child support, I say, well, you're paying that. Let's get the agreement in place. Don't make the lawyer come for you. It's like making a cop run for you. It's worse. Just pay it. And then everything else, we figure that stuff out. General options to defend a debt. One thing that I like to do is say, do not assume litigation is the right technique. Do not assume bankruptcy is the right technique. I probably turn away more clients than most. I'm a consumer attorney at heart. I actually like helping people. And my billables, they come. I'm a karmic type practitioner. I will make my money as it comes, and I'm not hurting for work. But I will tell people, no, it's cheaper just to not use me. Or it's cheaper to go to Northwest Consumer Law Center, or it's cheaper to go to the clinic, or wherever you can. So the first step you want to look at, what are your non-bankruptcy litigation options? Disputing pre-litigation, dispute during litigation, debt settlement, consolidation, bankruptcy, strategic default. These are all the general techniques that can use, and I'm going to go into a little bit more about them. Balance transfers. So let's say you're late on a card, they're getting ready to sue you, you got that nice 0% coming in your mail, just do that. That holds it off, and if you have a chance to get a better job, a chance to do some overtime, a chance to do something else, you've just now got the bad credit marks off your report because you stopped them from going 30, 60, 90 to 120, or even going to default and referring you out. You stopped the service of process fees, the collection fees, all those fees. You do not want your credit cards to go to the collector because they're going to double or triple them overnight with fees. Debt consolidation. I hate this. I hate it, and I'll tell you why. All you're doing is paying them to write a check for you, plus a $50 maintenance fee and whatever else they want to take advantage of you. If they claim they have the ability to settle, there's no special arrangement. I've been a creditor attorney. These people call me up and I laugh at them. I don't care. Give me all of it or I'm suing you. And they don't care because they're getting their maintenance fee. These are jokes. I've heard a couple that are actually decent, typically nonprofit, and I can't remember the names offhand. I just generally dislike them so much, but it is an option. Debt settlement. I love debt settlement. Whether I do it, whether I tell the client to do it, it doesn't matter. My general practice point, if it's under $5,000, is better for them to just self-settle. I don't care what deal they think an attorney is going to get them. It's just, if you got to go litigation, if you got to go hardcore, it's either here, you take this money, or I'm filing the bankruptcy. That's really the best technique. But if you have a high-income client, or even a middle-income client, you can try to take some of those debts off, the non-dischargeable ones, pay 50 cents on the face, whatever, wait a little time, and then file a Chapter 13 for the other stuff, or vice versa. I mean, there's lots of ways debt settlement is useful, and it's way cheaper than litigation in most instances. Usually for me to defend a case, it's like $2,500 plus just to get through the discovery, it's just expensive. Friends, family, usually zero interest loans. Excellent option if you can get it. And in fact, there's some very advanced techniques for mortgage debt that you would probably want to hear at some point. But anyway, yeah. Loans, imagine this. You're paying 23% on a card because you were late once or twice. You can go get a hard money lender that will lend you at maximum usury rate at 12%. They don't get the right to raise it up higher. It's actually better than the credit card. So once you max your cards, you can actually go to someone else, lower your payments, and then maybe even offer a settlement if you have to, or bankrupt on it. I mean, so never forget loans, hard money loans, family loans, whatever type of loans. If you can change that interest rate downward, that is a benefit, and sometimes that's the difference in cash flow. Mortgage options, go loan modification, deed in lieu, short sale. Strategic default's one of my favorites. If a client's in an upside-down house, well, dump the house. This is a no-recourse state. That means no deficiency if you walk away in most instances, unless they do a judicial foreclosure. And you come out with a very big net positive effect to your estate, plus you're not paying while you're living there. So you're getting rid of the debt and you're saving rent. It's a big swing, and it helps a lot of families survive. Pre-litigation options, you can read through this. Generally, this is between when they threaten you and before they sue. Now, the key here is this is just like, anybody do PI in this? Okay. So anyway, if you get the adjuster on the phone before the lawyer gets involved, that's your chance to make a good deal. If it's a low-value case, that's really the key. If it's a high-value case, they got to go to trial. So if you have a chance before it gets to that law firm, it's still with the collector, the $10 an hour employee with no sophistication, hopefully, you might swing a good deal. They're not doing their asset investigation. They're not really checking you out. They're not threatening you. They're just not trained to. So try to settle or deal with them beforehand. Threaten FDCPA, threaten FCRA, see what's there. Which technique is best? I'll just jump to the middle. If it's unsecured, Chapter 7 gets rid of it. If it's secured and you want to keep it, yep, always. It's already, they have that. When I was a creditor, we had, our floor people would have limits. It would already be on their screen. They know what they can settle for. They know everything. And if it goes above beyond that, they have to push the panic button. And then it goes to someone like me or, well, whoever does that job now. So yeah, so they're going to know what it is. Now, some of these people are really brutal. They get paid on commission, so they're going to pretend like they don't have authority, or they're going to play real hardball or whatever the case may be. What I find really is you make the offer and say, if you're interested, call me back. Otherwise, I'll be filing bankruptcy in 30 days. Just very nonchalant. They'll call back most times. So that's who you want to deal with, the low-level floor. You tell an attorney that, they'll pull their asset investigation. Yep, always, 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 because they don't want to do anything in writing. They'll claim they will, they never will. So what you do is you send a confirming fax, because you're going to have the receipt arrived, and you say, I talked to so-and-so at this time for this length of time. This was a deal. If I'm incorrect, please let me know in the next 24 hours, or otherwise I'll make payment to this address in this amount and this form of payment. And that's pretty much the way you do it. So always do the written confirmation. So again, unsecured debt, Chapter 7 is the best if you qualify. If it's secured and you want to keep it, 13. If it's secured and you don't want to keep it, you're back to Chapter 7. If you're dealing with priority debt, Chapter 13 or settlements the way you want to go. If you're very high income, settlement's actually better than Chapter 13. I steer most of my clients away from 13, opposite of most of my peers. Because if you're paying 100% over a 5-year term plus admin costs, why do that when you can settle 50 cents on the face, just stagger all the people, default one at a time, say you're getting 50, you're getting 50, you're getting 50. There's no reason to go into a 13. I hate 13s. I mean, they pay well, but that's not my point. My point is to get the best outcome I possibly can for my client. So I like my high-income clients paying settlements. Like I said, if the amounts in contribution is less than 5K, it's usually cheaper to avoid attorneys whenever possible. Leverage. So anyway, types of leverage. If you're bankruptcy qualified, I mean, I've just sent the letter to the other side and say, look, here's your taxes, here's everything. I'm filing this. You're not getting anything unless you take this $500. They'll take it sometimes. Sometimes they just challenge you. Counterclaims and defenses. So you got the recording where they call your mom something they really shouldn't have. Well, that's going to have its own value. You're probably settling for less than cost of defense. If a garnishment's already in place, so like one of Ibsen's clients says, haha, I'm already being garnished by the state, you're not getting anything. It could be 20 years till they get filed. So all of a sudden, a small settlement actually is worth it to them. So yeah, when my clients are getting garnished from the family law side, that's very helpful on my creditor side. If you're judgment proof, that means your money's hidden, filtered through someone else, nothing on record, no income whatsoever, great leverage. Medical condition, again, if you're not able to work, you got that doctor's note, good luck getting money. I actually have some militia clients that like to stay off grid, very challenging to track them. True, they're all types. And then, of course, the real issue is this. If I am going to litigate a case, I'm looking between original creditor versus debt buyer. So if BECU is coming to me, they have the records, they have the signed agreement, they have everything. There is no standing to prove. There really is no fight. The only fight I can do is like, you did this math wrong. And guess what? They don't do the math wrong. So there almost never is a fight, so I'm in a settlement scenario. And all I can do is say, in a Chapter 13 scenario, you're getting 80% of the debt. So therefore, why don't you take this amount, present value of money? It's a complicated package. When it's like ABC debt collectors, oh boy, it's fun time. I'm going to do a debt validation letter. I'm going to go after them. This is all free online. I don't charge my clients for this. I'm like, go to Google, send something like that in your own name, ambush them. They don't know I'm talking to you. And just have a lot of fun with them. And then once you get the evidence, bring it back to me. And then we'll determine if they have enough to go forward or not. Hearsay is rampant. And unfortunately, I've seen judges go all around the place. Sometimes they'll say, well, this person swore on appeal to perjury. Their records, their own computer says this is how much it is. I try to argue, well, actually, it should be the original creditor's document custodian that should be making that. Anything else is hearsay, and some judges buy it, some judges don't. It's very random. But again, it's going to cost a lot to get in there, so you have to look at the cost-benefit analysis. When debt buyers buy it, it's about 1 to 10% of the principal balance. So if it's $100,000, they probably paid $1,000 to $10,000 for the debt. So as long as you know the settlement points, so in that scenario, I might offer 15 to start, maybe max out at 30. Usual settlement points are in those. It just depends on do they have the full judgment. You're looking at probably 75 and 100% of the debt, unless you have leverage, unless you're bankruptcy qualified or something. If they've not gotten the judgment, you're usually looking like 30, 50. And if they haven't gotten the judgment and you have good leverage, it's usually 10. Below that, they've already paid for that. They're going to take their chance or sell the debt. Evidentiary and procedural defenses, it's just the usual stuff. Service, it's just like any other case that comes in your office. Service process, was it right? Standing, statute of limitations, amount correct, blah, 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 blah. You can read this on your own. With foreclosure and mortgage, there's only really two types of foreclosures. There's judicial and non-judicial. And it is just like it sounds. Judicial means there's a judge involved, non-judicial, no judge. The good news, if it's non-judicial, they waive the deficiency as to the person bringing it. So if you have a first and a second, the first brings the foreclosure non-judicially, the second can still get you because they're not waiving anything, but the first can't get anything out of you. So if you have one mortgage, you're in a perfect place to do a strategic default. If it's a judicial, they can come after you for the deficiency. But practice pointer, this state, they're lazy. They actually put in there, if you don't object to this complaint, we waive the deficiency. If you fight us, we want it. So it's a carrot and stick approach, which is wonderful. So when my client comes in thinking they're going to be sued for everything, like, you see that line? How about you just say, sure, here's the keys. And then they're happy, I'm happy, we're all happy. So don't be afraid if a person gets that suit, that it's the end of the world. General methods to resolve. If you're not keeping the house, Chapter 7 bankruptcy. If you do want to keep the house, you can look at Chapter 13. You can lien strip second and third mortgages, but that's a little complex. I won't explain that now. Litigating in state court, there's a lot of stuff online. There's a lot of self-taught lawyers, so to speak, that want to produce the note, produce the standing. They argue about MERS. They say all these things. The problem is they're going to bond you out of the suit. You're going to pay the contract rate for the privilege of litigating, and if you had no real case in the meantime, you might be hit for fees, you might be hit for a lot of things. I generally recommend don't go for that unless you truly have a title issue that's worthwhile litigation. And there's maybe about 5 attorneys in the state I'd trust that litigation. Strategic defaults are excellent, like I said before. Look at the cost benefit of the house. If you're upside down, definitely consider the strategic default, even if you have a second. Because you can settle a second for like $30,000 if it's $100,000. I mean, they'll take next to nothing. They're not doing asset investigations now. There's too many houses foreclosing, so you're dealing with a $10 an hour employee that says, bing, 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 10,000 on 100,000 notes, fine for me, because they're not expecting to get anything. And if it, because you're going to file bankruptcy in most instances. So strategic default is a wonderful tool. If you're truly lucky and have rich relatives, you can actually have them go and buy the house at the foreclosure sale, resell it to you for a small, friendly markup, and then you can actually get rid of a $500,000 house you owe on that's only worth $3 that was purchased for $280, and you buy back at $3 and you just save $200,000, all legal. So there are some great strategic default techniques, but a lot of it relies on rich relatives or something. There are some more advanced techniques where hard money lenders will sometimes do a lease back to buy option. So they will set you up, they'll buy it, and they'll say, we're going to rent to you at above market. So if market for this house is $2,000, they'll say you pay us $2,300. You don't have to move. You save those moving costs, stay there 2 years. This is the agreed purchase price now, which is above what they pay for it. So if they pay $200 at the sale, they might say we want $250 in 2 years. If you don't want it, you walk. We keep it. We rent it. If you like it, pay us. So there are all sorts of techniques out there that can create value for everybody involved, except the bank. And then I don't recommend deed and lose or short sell generally. You're going to make more money just staying there and taking the foreclosure. The credit hits are going to be equally horrible. And if your house is out upside down and you're looking at strategic default anyway, get more bang for your buck. I'd trade money for credit any day of the week. Because you only need it if you're buying a house or a car or qualifying for a loan. Everyone familiar with what Chapter 7 versus 13 is? Okay, it's pretty straightforward. Automatic stay. Once you file that bankruptcy, no creditor can do anything. So I frequently file a bankruptcy the minute before the foreclosure is going to happen. So I'm sitting there at 9:30 for a 10 o'clock sale. Click, and guess what? It's good. And bankruptcy court keeps time down to the second. So it's going to be 9:30 and 1 second. I mean, that's how specific it is. Bankruptcy exemptions. You do get to keep some stuff through it. You can look at this online. It's too long to list. Oh, the main thing in Washington, we have a very generous homestead. It's $125,000. So if you happen to have equity, you go state exemptions. Otherwise, avoid them like the plague. They stink for everything else. Go federal. Means test, that's how you qualify. Generally, it's just based on this. So on your family size, what's your gross income? That's the question. If you're above that number, it's presumed to be fraud, and you may be able to fit in, but it's challenging. And you're probably going to have some objection by the court, trustees, or creditors. If you're below that, hallelujah, you qualify. You're going to have an easy ride, most likely. Chapter 7 specifics, it's a liquidation. Again, don't need to go into that. Chapter 20, this is the fun one. What that is a 7 followed by a 13. The way this works is, let's say you have a house you want to keep, but you can't afford the payments to a 13. You have a whole bunch of unsecured debt too. So you're trying to say, do I want rid of the credit cards or do I want to keep the house? What's more important? So you file the 7 first to get rid of the unsecured debt. Then you turn around and file a 13. Now you can't get a discharge in bankruptcies less than 4 years apart. But the secret is you're paying all the secured debt you owe on the arrears. So you have the time to patch up now that your cash flow is improved. Courts do not like Chapter 20s. They see it as double the work. Well, that's not my job, is to make the courts necessarily happy. I just try to make them less mad at me. Example fact pattern, and this is basically the end of the slide, so we'll be wrapping up very soon. John and Jill are married with 2 children. They make 100 combined. So based on the means test, they do not qualify. That's where we start. They own a house. They're not current. They're $50,000 behind. The house is worth $4 between the first and second, and the house, or that's what they owe is $4, and the house is worth $250. So they're actually $200,000 underwater. 50 on the arrears, 150 on the mortgages. They have student loans, $50,000 for him, and he also has child support, $10,000. So $60,000 non-dischargeable debt, and then they have a combined $60,000 dischargeable debt. They have some retirement assets. They have 1 car with no equity, 1 car with $10,000 equity. So, how do we resolve this situation? This type of situation could be a Chapter 20. So you do the well, let's back up. They're not Chapter 7 qualified. So let's say for some reason maybe Jill's stressed, doesn't want to work anymore, or maybe John's stressed and doesn't work anymore. Let's say one of them has an injury. Now all of a sudden they qualify, or they could have more kids, whatever the case may be. It has to be legitimate. If you're looking at a fraudulent situation to reach a Chapter 7, the U.S. trustee will love to talk to you. And hopefully any attorney you talk to will not retain you, but there are attorneys out there that do that sort of thing. But if you can get qualified, then this is a very easily solvable situation. If you can't, if for whatever reason you can't stop working, it would impact your career too much, you're not a fraudulent person, you're not intending to have more kids, and this is your reality, you're sticking with $100,000, and you're not willing to do a separation, which again, fraudulent most likely, especially they catch you, you can't stay living in the same house, and say, oh, we're not married now. Oh, now we're married 6 months afterwards. It doesn't work like that. So you're sitting there with the house. So the first question is, well, you're $200,000 underwater, what do you do about it? Well, you could strategically default, work on settling the second, and then the first will go away in the non-deficiency, non-judicial foreclosure. Or if they do a judicial, they'll probably waive it if you don't fight them. So if you settle the second mortgage for only $30,000, that's pretty good, maybe for as low as $10,000. You also might wait for the statute of limitations to run. I've had a couple where it's gone beyond the statute of limitations. I even have one where I'm quieting title on the whole house, which is a lot of fun. All right, this priority debt, non-dischargeable. Well, that's where you make your payments. So if you do get into a 7 and you rip everything down, now you have the cash flow to just pay that. If you go the strategic default route, well, your money's got to go somewhere. You don't want to go to Tahiti, put it on your student loans. Credit cards, again, if you're doing the 13, if your house payments are large, you're probably paying less on those for the Chapter 13 plan, so it might be worthwhile. Don't do anything. Keep the house and just get rid of that debt. And then retirement, of course, is creditor immune for the most part, unless you obtained it fraudulently. So if you go rob a bank, put in your, Roth, well, it's coming back out with penalty. As far as the car with equity, you may have to give that up. So anyway, I hate to talk a little fast, but those are some of the solutions. All right, well, thanks for having me, and hope I talk to you again next year sometime.